So the High Court decided that we do not attend the right position based on the law of Malaysia in this part of the claim. Even though we are the exclusive sub-license of the duck industry, we should be able to maintain the similar claim as they do. Based on the Industrial Design Act, as our lawyer told us, we are entitled to have this rightful claim. So, therefore, I advise that we do not have anything loose to going to the appeal court. Who is favored in my decision?
I completely agree, especially after discussing with the representatives of the duck industry and getting the information that we are going to take the case into the appeal court. And with their support, I think we stand an even higher chance. And if it is time to prove that even as a licensee, we obtain a higher level of responsibility and our rights should be validated in the claims. And talk with the lawyers if they need any additional documents to prove our rightful place in the court, and there is nothing can stop our winning in this trial.
This appeal refers to the appeal of the second plaintiff in 1862-1866 appeal. The principal reason for this appeal that the second plaintiff, who was the exclusive sub-licensee of the first plaintiff, wants to prove that he has an appropriate standing in the lawsuit under the section 33 of the Industrial Design Act, shortly IDA, in 1996, contrary to the High Court decision.
Okay, so the second plaintiff appeals argues that the learned judge interpretation of section 33, specifically subsection 4 of Industrial Design Act, was incorrect, indicating a legal and factual error in his decision.
Let's hear Courtway raise perspective on this crucial appeal and the reasons behind it.
So what is the reason for this action that needs to be brought to this court?
First of all, based on section 33, subsection 4, the only circumstances of licensee of a registered industrial design has the right to file an action of a RID infringement is when the licensee has made a prior request to the RID owner to file a RID infringement suit request and the latter has refused or failed to do so within 3 months from the receipt of the request.
And see, what's the reason for the decision?
There are two things in section 33, subsection 4, Industrial Design Act, as it is clear from the use of the semicolon. This can refer to the Supreme Court judgments delivered by Yusof Chin, Session Court Justice, as he then was, and in critical things versus Dr. Bandar Kuala Lumpur, Golden Arches Restaurant Seberat, intervener. So the two links are as follows. An assignee, a licensee or a beneficiary of a compulsory license may file a registered industrial design infringement suit. For secondaries, if a registered industrial design infringement action is instituted by a person who is not RID owner, which is known as claimant, it must be proved that the claimant had made a prior application to the RID owner to institute the RID infringement suit, and the RID owner has refused to or failed to file as RID infringement action within 3 months from the receipt of the request.
Is there any act that's similar to this?
Yes, it is similar to Patent Act 93, Section 61, Subsection 1, Subsection A, and Subsection 3, which is stated the infringement proceeding by licensee and beneficiary of compulsory licensure.
I got it. But what does it mean by beneficiary?
Well, let me explain about that. This means that provisions of this subsection may not apply to any licensee unless the license contract stipulates otherwise or provides different provisions.
I have a question. Does this mean that we cannot bring the suit on the ground?
Yes, according to Section 33, Subsection 4 of the Industrial Design Act, the person with the right to institute proceedings for infringement is the owner of registered industrial design. Other than that, Section 3, Subsection 4 Industrial Design Act is interpreted that such persons may only commence action as the owner if the second limb of Section 33, Subsection 4 Industrial Design Act is satisfied.
I see. Is there any evidence that can make it clear?
Of course, this is made clear by the use of the word "but." To initiate infringement proceedings, a licensee must prove they requested the registered owner to institute proceedings within 3 months, but the owner failed to do so.
Wait, what are we going to do now?
Based on the High Court judge, we need to prove that we had made such a request in order to have the required standing to sue in law.
How to do that?
We need to make a prior request to the registered industrial design owner to file registered industrial design infringement suit, and it must be done within 3 months from the receipt of the request, but we failed to do so and there is no written request for use. But the High Court judge found out that the site licensee was not a licensee of that industry and therefore will not fall within Section 33 of the Industrial Design Act, and your company was required to prove that a request had been made to the industries to initiate infringement proceeding to qualify for standing to sue properly under Section 33 of the Design Act.
May I know what is the facts can be related to this?
To begin with, Section 29, Subsection 6 of the Industrial Design Act provides that the owner of a registered industrial design and must be read with Section 3, Subsection 1 of the Industrial Design Act, which defines owner of a registered industrial design as a person who is registered as the owner of a registered industrial design. Then the infringement provisions are placed in Section 32 to 35 of Industrial Design Act.
May I know whether a sub-licensee is a licensee?
Okay, let me explain that. Do you know what is exclusive right?
No, I didn't, and I believe you know better. What is this?
Well, in order to understand the nature of exclusive right that contemplated under Section 32, Subsection 1 of the Industrial Design Act, it begins with the one characteristic shared by all the types of intellectual property today, that is that rights granted are essentially negative, which means they are rights to stop others from doing certain things.
Then who has the right to do that?
That's a great question. The right to stop pirates, counterfeiters, imitators, and even in some cases, those parties who have independently reached the same ideas from exploiting them without the licensing of the right owner.
I think we are lacking the standing to sue this proceeding. Actually, we are not eligible for the exclusive license. Our license is for us to manufacturing and selling the product.
No, don't give up yet. I found that in the Industrial Design Act context, there is no corresponding requirement under the Industrial Design Act that a licensing must be exclusive. The Act also carries a wider principle that the end result of the transition is that Tupperware brand is licensed under the registered designs, and it does not matter that this result was reached by two transitions, a license followed by sub-licensing.
Oh wow, that's good news for us. Okay, now do our appeals accept it?
Yes, your appeal is the correct proposition of the law.
So does the High Council jurisdiction can be used?
Based on our above findings, your company does not require any consent to commence any proceeding concerning by infringement of intellectual property belonging to that industry under Section 33, Subsection 4 of the Industrial Design Act.
So this means that we have the right to sue?
Exactly. On my view, Tupperware brand is also a party to the section in that industries. Co-plaintiff does not answer this conclusion, nor that is there any warrant for nationally dividing a single action brought by two plaintiffs and treating it as if there have been two separate actions brought separately by each plaintiff.
Glad to hear that.